Hi, it's me Prakriti. Today I am here going to present about the Parramatta versus Sadok and Association case. And we have four members, including me Prakriti, Durga Nupani, another Nikki, and Uday sir. This is the case of SADC and Association Associates Private Limited versus Parramatta City Council. We are going to talk. We are with SADC and Associates Private Limited. That is, we are against Parramatta City. Um, Here, SADC wanted to purchase property governed by the council. SADC, before buying, asked the council whether the property was the subject of any proposal to widen roads. The council carelessly said there were no any such proposals. Later on, road was widened and the value of property decreased. The appellants claim that they are sustained loss by reason of their reliance on erroneous information supplied to them innocently but negligently by the respondent. Issue: does Parramatta Council own duty of care to SADC and Associates Private Limited? Does Parramatta Council breach duty of care and liability for providing erroneous information, whether the damage or negligent misrepresentation exists or not? And the law will be followed by my friend Nikki.
Now I would like to introduce to you the law of tort. The law of torts is an area of the law that often only becomes relevant to people and businesses after the happening of loss-making event. These laws can be economic or physically loss. The tort law protects many interests include negligence, private nuisance, trespass, and defamation. Elements of law of tort. There is tort rests on two principles: an act or omission by the defendant interfering with rights or interests of plaintiff, thus causing the damage. The interference must give rise to a cause of action for damage. And the next one is the negligence. Negligence is the omission to do something which a reasonable person would do, or doing something which is a prudent and reasonable person would not do. Negligence is the failure to exercise reasonable care and skills. There is the elements of negligence action. The plaintiff must establish on the balance of probability civil action that includes the defendants owed them a duty of care, the defendant breached the duty of care to them, or they suffered damage as a result of the breach. The next one is the negligence misstatements. A statement of fact, advice, or opinion made in business that is relied upon by another, but which is inaccurate or misleading. Duty on the defendant to avoid making careless statements which cause harm. This, according to Hadley, Barry, and Heller, 1964, established that the law will imply a duty of care in the making statement. Next one I'm going to say about a duty of care. A duty of care was first formulated by Lord Aiken in Don't Go Here and Stavations, and is a question of law for the judges to decide based on the neighbor test. May be summarized as follows: you must take responsibility, careful to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Much of the law negligence relates to what a reasonable person would do. The reasonable person is someone of normal intelligence, credited with such perception for the surrounding circumstances and such knowledge of the other pertinent matters as a reasonable person would possess. Secondly is breach of duty. If the duty of care questions is decided in favor in the favor of the planet, it then becomes a question of fact whether the particular conduct complained of is a breach of that duty. The standard of care is an objective one, and the standard required is that reasonable person. This is a question of law. Standard of care is that is expected, that is that a reasonable person equipped with the same skills and expertise as the defendant and how they would have acted in the defendant's position. And third one is the damage. The plaintiff must show some link between the damage suffered and the defendant's conduct. Two factors for the consideration are: was the loss or damage directly caused by the defendant's breach is called factual caution, or is it appropriate for the scope of the negligent person liabilities to extend the harm so caused, so it's called scope of liabilities. Lastly is defenses. Two defenses can be raised by a defendant and of the burden of proof test with them, contributory negligence and voluntary assumptions of risk. Now I'm back to my members who's going to discuss about the application.
Thank you, Nikki. Now I will talk about applications. Council is the most reliable source to get information regarding development of that area. Here, council owe the duty of care to its public. When SADC and association company asks question about the construction to council, they reply they don't have any plan to widen the road. But later on, when SADC and association company did the contract to buy the property, they widened the road, which result to decrease the value of property. Here, negligence of council affect the business of company. There is no doubt that the officer of the council who answered the telephone was careless in stating that there was no local road widening proposal affecting the land. And given this, it was unnecessary for the council to have used skill or competence in answering the inquiry which attract the duty. It could be informed from the fact that the council acted as a center for the distribution of such information that would exercise the requisite care. If the concept of the reasonable man can apply to negligent act performed by the man in the street and the man in the white coat, then surely it can apply to negligent oaths, no matter where on the continuum for ordinary to skillful the purveyor falls. In conclusion, here council who have a duty of care to its public and council all attempt and decisions has impact upon to the general public. So in this case, Parramatta Council is responsible to bear the loss of SADC for SADC and Associates Private Limited. Here are listed of some references which we included in our slide. That's all. Thank you.